Breaking news. Presidential poll. Abuja can't be 37th state. Atiku, Obi tell Supreme Court. Determined to nullify the election of President Bola Tinubu, candidate of the People's Democratic Party, PDP, Alhaji Atiku Abubakar and his counterpart in the Labour Party, LP, Mr. Peterobi, yesterday, lodged separate appeals before the Supreme Court. The two candidates, in their appeals, prayed the apex court to set aside the judgment of the Presidential Election Petition Court, PEPC, which affirmed Tinubu of the ruling All Progressives Congress, APC, as the winner of the February 25 presidential election. Specifically, they argued that the lower court erred in its judgment because Tinubu did not get at least 25% of votes cast in the Federal Capital Territory, FCT Abuja, adding that the Independent National Electoral Commission, INEC, deliberately refused to transmit the results of the poll electronically to its portal in accordance with its guidelines. They also argued that the PEPC glossed over their claims of manipulation of the poll, conducted in breach of the Constitution and Electoral Act in spite of their weighty evidence. Whereas Atiku, through his consortium of 67 lawyers that comprised 18 senior advocates of Nigeria led by Chief Chris Oche, SAN, filed 35 grounds of appeal to challenge Tinubu's victory, Obi, through his own team of lawyers led by Dr. Livy Uzokwu, SAN, filed 51 grounds of appeal before the apex court. Specifically, Atiku, in his appeal, maintained that the verdict of the Justice Haruna Samani-led 5-member panel of the Court of Appeal, which had on September 6 dismissed his petition against the outcome of the presidential election, was not only against the weight of evidence, but occasioned a grave miscarriage of justice against him. The former vice president insisted that the PEPC panel erred in law, when it failed to nullify the presidential election on the grounds of non-compliance with the Electoral Act, 2022, even when evidence that was adduced before it showed that the Independent National Electoral Commission, INEC, acted in breach of extant laws and regulations guiding the conduct of elections. In his own appeal, Obi, who came third in the presidential poll, maintained that the PEPC panel erred in law and thereby reached a wrong conclusion when it dismissed his petition. He alleged that the panel wrongly evaluated the proof of evidence he adduced before it and occasioned a grave miscarriage of justice when it held that he did not specify polling units where irregularities occurred during the election. Obi and the LP further faulted the PEPC for dismissing their case on the premise that they did not specify the figures of votes or scores that were allegedly suppressed or inflated in favor of President Tinubu and the APC. He told the apex court that the panel unjustly dismissed his allegation that INEC uploaded 18,088 blurred results on its AREV portal. More so, Obi alleged that the lower court ignored his allegation that certified true copies of documents that INEC issued to his legal team, comprised of 123 blurred results that contained blank A4 papers, pictures and images of unknown persons, purporting the same to be the CTC of polling units results of the presidential election. The learned justices of the court below erred in law and occasioned a miscarriage of justice when they held and concluded that he failed to establish the allegation of corrupt practices and overvoting, Obi added.